All right, you should be good to go, Catherine.
All right, good afternoon. It is afternoon, 2:04, everyone. I am trying to find the agenda because that's how I roll. Here it is. Welcome. Check. I just welcomed everybody. Yes. Before I do that, let me give the Ethics Act statement. It is the duty of subcommittee members to avoid conflicts of interest in performing duties as a member of the subcommittee studying unbundled legal services of the North Carolina State Bar. Any member of the subcommittee who is aware of any conflicts with respect to the matters before the subcommittee should disclose those at the meeting. Anyone have any? Excellent. So first we have the meeting minutes from March of 2023. I'm sure everyone has reviewed them. Does anyone have any edits, or do I have a motion?
So moved.
Thank you. Have a second?
I second.
Thank you, Daryl.
Good afternoon.
Good afternoon. Daryl's got the best office anyway because he's got the guitar back there. That's the coolest.
This is really not my office. I'm just.
Are
kidding.
you serious?
No,
Oh.
I'm just.
You had me. You had me. All right. Any further discussion about the minutes? All in favor of approving the minutes as presented, say aye.
Aye.
Anybody oppose? Or raise your hand. Sorry, Jennifer. I looked up and I see Jennifer properly raising her hand, and I'm like, oh, that works better on Zoom. All right, so the minutes are approved. And so our next item is to review the draft rule on limited appearances. And I'm going to let Mary or Brian, I don't know who's taking the lead here. I'm going to let you all talk about this draft that we got.
Yeah, so I'm going to basically give an overview, and then Mary is going to kind of take us section by section because the charge at the last meeting was staff create a rule that we can start, just kind of have a starting point for this conversation. So we did that. Mary and I met, and we looked at a number of different jurisdictions and their existing rules. There's really a spectrum of rules here that you see across the country, where there are some that are very detailed and others that are very much not. And I think there's strengths to both, right? Details provide a lot of guidance, but they also sometimes can produce a bit of inflexibility, and of course, when you don't have those details, then you leave it to the parties, the court, to adapt as they need to, but you may create a lot more confusion and questions. So we try to kind of strike a balance of trying to hit the key aspects of what this rule likely needs to discuss and set out for people to know exactly what they're getting into when they're making this limited appearance. So I'm going to go ahead and I'm going to share my screen just so we can go through the PDF together. And this is where we have our limited appearance. Of course, you would start off just by kind of saying, this is kind of a couple of different options as far as, do we include this in Rule 16? That's the general rule of practice that we've been talking about this whole time that really prohibits this type of process. So we could put this in Rule 16, seems like a natural fit there. Could be a different rule. We've seen different jurisdictions do different things. So that can be, maybe a different conversation, but it's clearly not a material part. The material conversation is getting into just what exactly we're talking about here. So again, without getting into, I'll leave the details to Mary, but we try to kind of hit on just what is the limited appearance, specifically referencing Rule 1.2 in the Rules of Professional Conduct, because that's where we have ethical permission to engage in limited appearances so long as they're reasonable under the circumstances. And then we wanted to hit on notice and service, just what does the notice need to include? How is that served? How should it be served on the parties and so forth? How should it be filed with the court? And then getting down into kind of the things that can happen during the representation, the scope, if and we pulled from some other jurisdictions here about, if an attorney in this limited representation starts doing stuff outside the scope of that stated limited representation, that essentially there's a consequence. That's making a general appearance in the case, unless there's some sort of amendment that was filed to extend the scope for whatever action the attorney is engaging in. And again, that's what the scope and the additional requirements section really try to just kind of hash out just what could happen during the representation. This is where we saw a lot of divergence between the states, all right? Because this is where you can get very detailed, or you can not address any of this at all and just leave it to what happens and react. And so we're looking forward to some feedback there. And then at the end, you'll see the withdrawal section. We had kind of two different alternatives here. Withdrawal, one that kind of requires the court to still enter the order allowing the person to withdraw, but really kind of putting it on this pathway that doesn't allow the court much room to go a different direction. As long as the lawyer's done everything that they said they were going to do, they filed the notice concluding the limited representation, they get out. But then the alternative basically does not require the court's permission to actually get out. It's kind of a presumption that lawyer, once you've done the limited representation, you filed the notice, you've said, I've concluded that limited scope, I'm done, then as long as no one objects, then lawyers presume to get out. So it's kind of a, it's the result is the same, but how you get there is slightly different. And we're looking for some feedback there. So like I said, we thought that the easiest thing to do here would be to go and talk section by section about what we did, why we made some of the choices we made, and ultimately wanting to get feedback here, because I think Mary and I both look at this as, like we said, so many different options across the different states. This is one of those things that we can have a lot of reasonable conversation, maybe even disagreement on what needs to be in here. We do not take any sort of pride in authorship, so please feel free to tear it up as you feel it needs to be. So with that said, Mary, I'll hand it over to you and you can get into all the detail.
Sure, that sounds great. So Catherine, what I plan to do, if it's all right with you as chair, is to just start, take each section one at a time, and we can pause for any comments or feedback or suggestions.
It's perfect, Mary.
Great, okay. So the first section, A, is really just stating the allowance for an attorney to be able to appear in a limited way. As Brian mentioned, we did kind of track that back to the Rule of Professional Conduct 1.2 that gives guidance from an ethics perspective. We felt like that was a good way to tie it. And then we also include a provision here that says the attorney cannot make a limited appearance for only the purpose of making evidentiary objections. That was something that we pulled from Massachusetts and felt like that must have been an issue that they've seen. I think it was actually in more states than just Massachusetts, but Massachusetts did a good job of laying out some of those issues. And so we included that as well in that section. The first
yes,
one,
I guess we're going to pause after each one of these sections just to see what you all think. If there's anything that you would change, you think is appropriate, inappropriate, whatever it may be. But we just love to get some feedback as we go through these sections.
I like it. I mean, I think that makes sense. I don't know how often the evidentiary objection comes up, but I do think that would be an unusual and awkward type of limited appearance to just say I'm here to object. So I think incorporating that limitation makes sense to me.
Anybody else? Mary, it seems like we are good on that section.
it's the shortest one, so
Yes.
it's a good time to move on. Okay.
Dion wants to know if we can have I'm pulling it up, Dion. If you can share the screen.
Each section, that might be helpful. Yeah.
Sure. Do you want to do that, Brian, or you want me to do it?
Yeah, I can do that.
Okay.
Put that right back up there.
Okay. So the next section goes on to notice and service, starting with the requirement that the attorney file a notice of limited appearance with the court. It sort of sets out what needs to be included in that notice. A lot of states accomplish this by a form, and so some states basically just reference the form, but this is sort of the substance that seems to be necessary. But the contact information for both the party or parties, and then also the attorney, and then a description of the scope of the limited service, including the specific court proceedings that the person is intending to represent the individual, and then also any specific issues where that limited appearances, where they're going to be appearing on behalf of that person. So the other piece is that the notice is to be signed by both the attorney and any parties. And then the next paragraph there gives a little bit more detail about how it's to be served on the opposing party or counsel, if appropriate. And then once filed, directs the other party or counsel to serve any pleadings on both that attorney that's making the limited appearance as well as the party. And this is common, I would say, through a lot of the rules that get into the details. This particular provision is common to address the issue of, presumably there may be motions or pleadings during the life of the case that don't relate to the limited appearance. And so this seems to be at least one way of handling it, is for any filings to be served upon both the party or parties and the attorney making a limited representation.
And I want to add real quick that this was one section that I know I kind of tumbled around in my brain, such as it is, when I was thinking about this, of thinking that, we are telling the lawyer that's making this limited appearance to restrict their scope, and that they do anything outside the scope of this limited representation, that might be a general appearance. And so do we need everything to be served on the limited appearance attorney? And ultimately, I guess I kind of landed in the spot of thinking this was appropriate, because without serving everything on it, you're asking opposing counsel to determine what is and is not within the scope. And so it seems more appropriate to just say, okay, serve it on both the party and the lawyer, even if they're a limited appearance. It may be outside the scope, but that's something for lawyer and client to determine, and lawyer needs to properly refrain from that. But lawyer won't be able to make that decision if they don't know what was actually filed, served, et cetera. So that's why I think we landed in this spot thinking that this was an appropriate remedy to that concern. So, but we'd love to hear your feedback.
So Brian and Mary, is there anywhere in here there's a duty to supplement, like if the party moves? Because I see that it's in the initial notice, limited appearance notice, but what if that party moves?
No, that's a good point. That is not in there. I guess that's kind of one of those presumptions that could be I guess it could be understood by everybody who's being reasonable, but very well, you're right. We need to have something that there's an expectation that the contact information and so forth will be supplemented.
Well, I think that's important, because just now, even in court now, when there are self-represented or pro se litigants, that's always an issue for the clerks trying to serve people with orders or whatever, and don't have the right address, and it's a real problem. So I think that if they need to have, it needs to be an affirmative duty to make sure that there's a current address. I think it's my opinion.
I think that's great.
I would agree. Can we say something like, notwithstanding this provision, the party has an affirmative obligation to keep the whatever the court system requires, keeping it up to date. First of all, I don't think a lot of pro se individuals know that, but it may be worth putting in this rule.
I think that's great.
Is that something that exists? This is going to be showing kind of my knowledge of and not active use of the rules of procedure. But is that something that exists somewhere already? Do we think within the rules that affirmative duty to keep it up to date?
I mean, we're talking here about an unrepresented person. So, I mean, I think lawyers know they have to keep the court informed of their current address, but now we're talking about a citizen.
I think sometimes there's local rules that I've seen that require it, but I don't know if it's anywhere in this. And the thing, and the question I had, it looks like we're requiring all pleadings, even, whether or not they're the limited scope or not, to go to the limited appearance attorney. I guess this would mean that this would be different communications, though. There would be a decision that the opposing counsel would be making as to whether or not to communicate, whether or not their issue would be one of the limited scope versus the not limited scope. Is that what this is saying? I mean, just the pleadings, but the communications, that decision is being made by the opposing counsel, right?
Yeah, I think you're right, Dion. I guess that'd be a question to everybody. Do you think it should be once you file this limited scope appearance, then should you simply receive everything? That both your client and you, the lawyer, should receive all letters, emails. You're right. This is really only restricted to pleadings, but there very well could be a quick email about something, and that's a decision made. So perhaps it needs to be broader. But would love to get everybody's feedback. So you also want it to be practical too, right? Not just inundate the limited appearance attorney with everything that they now have to sort out and contact the client. Hey, we just got this email. Just want to make sure you saw it because I'm not responding to that. But perhaps in this context, that would be an appropriate thing. So we just, as we write this, love to get your feedback.
Well,
How is that handled in other states? Do we know?
Mary, I don't remember seeing stuff about specific communications. It's really pleadings, and that's where our minds went. It was going to filings.
Right.
well,
We could go back and look, but I really don't remember seeing anything specific on that.
well, it's almost like a
Eric?
limited appearance with the general field, though, because I would still feel obligated to turn any emails over. I'd have a problem just saying, no, you can't really email me. You need to email my client, but I won't respond, I imagine, to things that I'm not, hired for or outside the scope of my limited appearance. But I think if the opposing attorney is going to allow you to, do or accept the fact that you're doing a limited appearance, probably should make it clear that, anything that's outside the scope of what should go directly to the client.
But how many times do you have emails that cover multiple things?
I know.
Are you going to sit there and have to parse out the email?
Yeah, exactly.
Because then you run into a potential rule violation of, are you communicating with my client without my permission?
Right.
Well, and I wonder about who we should put the burden on. I mean, if one of our charges is to protect the public, it sort of seems like everything should go to the limited appearance attorney, and then the limited appearance attorney now has an obligation to sort that stuff out.
Yeah, and forward it. I would just feel uncomfortable not, passing that information along to my client unless I would still pass it along, even if it's not what I've signed up for. I think I would have a duty to at least keep my client aware. And I think it would protect the other. I think it would protect the opposing attorney too.
Yes.
From not getting into a situation like what Matt said about, not, talking to your client without, the attorney. Because that could delve into, I know it's limited, but, I want to talk to you. What if your client starts talking to him about that? Something that's, outside your scope of representation.
I want to cover two points that were brought up, or one that was brought up, one was not. Addresses in the notice of service part, I think it is definitely good to have those addresses. We have a lot of pro se litigants, and we mail stuff out to them as part of notices, and a lot of those mailings are returned. So what we've asked attorneys to do as part of their order to withdraw, so that's on the front end where we're saying in the notice, I do agree with having their address, the current address in that notice when they do their notice of appearance, limited appearance. But also part of their withdrawal is updating the address. So as part of, I'm withdrawing from this case, here's the address, whether it be the same address or whether it be a different address. So this is a way that when they get out, courts can get their most up-to-date address, phone number, fax number, email, whatever they may have. Second part of it is we did not bring up, but to think about is Odyssey. which is currently rolling out. We're supposed to be next to get it whenever that is, and that's in Mecklenburg County. But with that, depending on when the action is filed, attorneys will have the ability in portal to see the case and all documents that are filed in the case. So I'm just posing that out there. If that's something we want to think about, what information will already be available and what information won't. We know emails won't, but pleadings, complaints, motions. If it's a new case, once Odyssey is in that county, the attorney would be able to see that in portal without needing as much on discovery potential. Don't know how they're gonna write the discovery rule. Just something to think about.
Dr. Rice, in the withdrawal part, I believe it says that you have to have an updated address in the withdrawal, whether it's by order or agreement. I think that's included. It's already in there, right, Mary? It's already in there.
Yes, we did include that. And some states say last known address.
Yeah.
We could say updated address, or kind of put more of that duty on them, not just to copy and paste what was in the original.
And I think obviously once we can run this by AOC, to see if language needs to be tweaked because of e-courts. But I mean, even if the pleadings still have to be served, even if, I'm in Johnston, we're part of the pilot counties, you have to still serve, even if it's in Odyssey, you still have to serve it. The pleadings. But.
Well, I think one thing we could do is.
Sorry.
Oh, no, go ahead, Dion. Go ahead.
I was just saying, I think, there is that rule change that is apparently supposed to eventually, allow service through Odyssey if you have an email on file with the clerk. But again, I'm not familiar enough yet with Odyssey. When you're having this sort of dual requirement to serve the person and the attorney, and to make sure all that gets into Odyssey, so you can make sure Odyssey knows that there's two people to serve, or 3 people, or ever how many. But I haven't really thought through. I'm glad that he brought that up. I haven't really thought through Odyssey much with this.
Well, I want to go to Dorothy, but what I was going to comment on is I think you have to go in and put yourself as a service contact on the file. And so it may be that there's tweaking to the language to say, something like when and if you get Odyssey, you have an obligation to make sure, your address is in there, your email address is in there, along with the pro se party's email address. So we should be able to at least flag that at some point. But Dorothy, you had your hand raised.
Yes, thank you. I don't want to repeat what has already been said, because I agree with a lot of what was already said, but I just wanted to make a point about the updated contact information. I think that instead of just what you suggested, Mary, about something about if they have any updated address, I think it should specifically have a requirement that they have to provide an address and contact information and all of that, even if it is the same, because so many times people will assume that their current information is on file and it really isn't. So just to try to prevent that from, that we're losing people in contact information, I think it should just have it as a requirement. And thank y'all for letting me not have my video on. I'm actually officially on vacation this week, but I realized I had a little pocket of time to jump on when I didn't think I would. So I'm here though.
It's okay.
Dorothy.
You got a beautiful photograph, Dorothy, and I know what I look like when I'm on vacation. So I would have my photo up there too.
I appreciate you.
Enjoy yourself.
Thank you.
I was wondering about the requirement for signature. I know, like if you just file a regular notice of general appearance, you would not have the client sign that. We've got a requirement here that the party also signs it. I assume the idea is some confirmation that the client understands the limited scope, but I wonder about that, since we don't have that same requirement for other notices or appearance, or, when you're filing a motion or an answer or anything like that, we typically don't have clients sign what the attorney's filing. So welcome.
Right. Yeah. And Mark, I mean, you're hitting the nail on the head. This is one of those things where we knew this was a little different. But in this context, when you're talking about limited scope, depending upon the scope, it could just be kind of I'm taking you through this stage, but otherwise I'll be here for all the things. Like I'm taking you up through mediation, whatever it may be. But it could be something as I'm only representing you for this deposition, for this one hearing. And I guess that was kind of when you're trying to figure out where do you strike the balance? I landed in this spot personally of, I think the party should also sign it because you want that acknowledgement that, if the, and I guess this is that whole thing of trying to ensure clarity. I feel like as Mary and I were talking about this, we kept on coming back to really the priority, the principle is clarity. It's understanding for everybody involved, because this is where things can get so confusing. I'm only supposed to do X, Y, and Z. And well, I thought you were doing A, B, and C as well, and all that. And so that's where it's kind of trying to get everybody on the same page, memorializing that for a potential, hopefully not, but if there is a potential dispute down the road. So we kind of landed on having the client sign it as an acknowledgement to not just the lawyer, but also the court. But you're right, we don't normally do that for general appearances. So
Brian, my concern is we were having them, I'm jumping a little bit ahead to withdraw, but we're having them sign on the front end, we're having them sign on the back end. I would prefer only one or the other. That if you don't sign on the front end, then you consent. I mean, kind of like you have to consent to withdraw now or a hearing. So I would prefer, I tend to agree with Mark on this, let it be without the signature on the front end, or have it on the front end, but not on the withdrawal side.
Gotcha.
I would vote to have it on the
And
front
Brian,
end.
I was looking at the AOC G312, which is the notice of appearance by counsel. That form is new as of March of 2020. Notice of appearance by counsel. It does not have a place for the litigant to sign. It does have a checkbox that says counsel's appearance is limited, such that counsel will represent the parties only to the following. And it gives about 5 lines for them to fill that in. And then plus there's an agreement that both parties sign on that limited agreement. I think that kind of handles the front end where the notice of appearance doesn't need it. But I do agree that it should be on the back end to ensure there's some agreement to it on the back end. If not, there's a hearing process if there's no agreement where the judge can resolve whether they can withdraw or not.
Marcy.
I don't know. I know that not all litigants are as sophisticated. I just worry that I just feel like if you sign it, then you can't later say you didn't realize that the limitation. If what we're trying to do is to get lawyers that are willing, at least in the family law context, getting them to come in and maybe do something pro bono if they know they're not going to get stuck for years, or do it for a lesser fee. I just feel like I think the litigant needs to sign it, because then they can't come back later and try to keep the lawyer from getting out by saying, well, they didn't tell me and I didn't know, so they shouldn't be able to get out. I mean, why not just make it very transparent to everybody? Why not? I mean, I don't know. Maybe somebody can tell me why I'm wrong.
Marcy, I was going to say I agree with you. I think yes, the contract that they can have can be an acknowledgement, but this is an acknowledgement to the court system by everyone that we know what the pro se person is going to be doing and what the attorney is going to be doing. And I was going to actually add a statement that essentially said, and by signing something like the pro se individual knows that there's an affirmative obligation to keep the court up to date with their address.
Right.
Because they may not know the rules. And again, if one of the things we want to do is protect the public, I don't know how putting that in there would be harmful. It would just be one more place where they've been reminded, of what they should do, even if they have an attorney, because I think that can be very confusing to somebody.
I think you got Dorothy, Catherine.
Oh, yes, Dorothy, please.
I was going to say, I agree 100% with Marcy that it should actually be an acknowledgement and a signing by the client. because while we want to protect the client's interests, we definitely want to look out for the lawyers too, because there's so many instances in which a client, a pro se litigant, will come in and say they didn't understand something. But if there's a clear indication on the paperwork for the court, that makes it easier for the court too to be able to resolve those issues. I mean, it's just there. There's no question about it. So I actually agree with it being a requirement that they sign on the front end and the back end, just so that it's continuation of the acknowledgments by them that they understand everything moving along through the case.
Well, I also like, even when I make limited appearances in like criminal matter, I put it in my fee agreement too, so that they understand what I'm representing them for and what this fee will cover.
Yeah, I think it definitely should be part of the written engagement letter, but I think I'm persuaded by Marcy and Catherine and Dorothy's comments that probably on balance, it's a good idea to have something in the court file that has the signature on the scope. So you guys have persuaded me. It's probably on balance better. I don't know if Matt and others are persuaded, but I'm persuaded. So.
I don't argue with Marcy. Well, I do, but
we're in domestic court a lot, and we see a lot you guys don't see. And I'm thinking, again, if one of the purposes of what we're doing is to have more access to justice and having people be willing to sign up to do pro bono or to do low bono or whatever, then they got to feel like they're being protected, against having to. And then if you get a judge, if they didn't sign it on the front end, they could go in and say, well, judge, that's not what this lawyer said. And then the judge can say, well, I'm not going to let you out because they didn't understand. And then that just defeats the whole purpose.
I agree, Marcia, because I'm assigned to family court right now, and I've seen so much of this. As well as I would even suggest, and even if we don't have one going statewide, I'm even thinking about a local form that we may need to have once, if all this goes into play, that we have a form that if, say you have an attorney that was, there for this one service, this one piece of the litigation, but then they come in and they decide out of goodwill that I'm going to help them with this other piece too, but that's not what the client originally signed and acknowledged that they would, that the attorney will represent them on. And we can have a little short form in the courtroom where those acknowledgments can be taken care of right there in the courtroom. So that can get in the file too, just so it can be a continuation of that, because it really can become a lot. And then I've also found myself to be one of those lawyers where I have pro se litigants, and I'm asking, a lawyer in the courtroom to be a friend of the court and assist with these things. And lawyers really like to do that, but I also want them to feel protected when they are doing it, as opposed to just kind of going into these things blind.
I feel like if this becomes a reality, I feel like AOC is going to have a forum, or we'll do a forum. I think that will happen. we can make that happen, I think. But yes, I agree with you, Dorothy.
That might be a good transition into the next section on scope, because I think there's some pieces here that actually relate to what was shared, unless anyone else has further comments about the notice and service section.
Well, the only comment I had, and this is, I think, very particular to the family law aspect, is, if someone's representing somebody in, I don't know, a very limited matter, let's say a deposition, we have a lot of financial documents that go back and forth. And I don't know why, it just gives me some heartburn if I know the limited appearance attorney is not touching at all the financials, but somehow when it says pleadings and other documents, under our local rules, I would be obligated to turn over, banker boxes in some cases worth of financials. And I don't have an idea. I just had a statement. Maybe the other family lawyers have another thought on that, but that just seems like something that could be too much. And I certainly could have a client, not be thrilled that I'm having to hand out financial information to one other person. I understand their attorney, but still some people are very protective of that information. But that's just a comment without a resolution.
Yes, I'm still I haven't gone far enough because I was still thinking about the communications piece, but you're right on discovery. That could be quite an effort. I know we have, we can burn it on thumb drives and things like that, but it does seem like this person who may just be in the custody case is suddenly going to get inundated with lots and lots of financial discovery.
Or cases
something
where we have protective orders.
Yeah.
Right? Protective orders around documents that can be disclosed or therapist notes, right? If someone's only appearing for the purposes of having the divorce entered, but then I have to have them, noticed on the protective order about therapist notes. I don't know. I have to think of it more. Maybe there's other areas of law that have this sort of issue, but it's just something to think about on family law and that is a subject area I think a lot of people would be willing, and there's a need for pro bono or low bono work. So,
well, do you all think this might be a spot where we could separate out? We talked about communications, and I think pleadings are things that we feel like the attorney, the limited appearance attorney, should receive all of those. But any sort of documents, responsive documents, like discovery matters and all that, perhaps that could be separated out as kind of as agreed upon, or maybe there's a presumption that you're going to provide that unless another agreement is reached, because it's, the other side is kind of the person, the opposing counsel, who's now dealing with limited appearance counsel, and you've got a banker's box of documents that you need to send to the client and the attorney. That's another burden. Like we don't want this to be so burdensome that it just grinds everything to a halt and makes people frustrated. It's supposed to be a helpful avenue. So do you think documents should be separated out from communication about the representation? And I guess maybe we need to flush that out, right? Like what exactly do we mean communication? But basically communication between, essentially opposing counsel or opposing party and the represented party. But pleadings, communications are one thing, documents or responsive documents are another. Is that a potential solution?
I think so.
Yeah, you could
I
talk
know we
about,
gotta, as you said, we need to flesh it out, but I do think that we should consider separating out the documents for that very reason that was already stated, that could really prevent people from wanting to make these limited appearances if they're going to be inundated with all those different documents. When really, if they have the notice and the pleadings, if it's something that they notice in the notice or the pleadings that they really need, or that they decide they're going to represent the person on, expand the representation, then they can request those documents from the other party.
I do think you should have, documents that are relevant to the limited scope issue, though. The discovery or documents.
I agree.
You could just limit it. And so maybe I could just kind of work on the wording there.
Right.
Maybe think about that a little bit more.
It just gets tricky,
Marcia,
right?
that's what I meant. Yeah, I'm sorry. That's what I meant, to limit it to just those things that you're making a limited appearance for. But all the other documents, that's not what you're representing the person on.
Right.
You wouldn't need them. And if you do, you can just request them.
I was just saying, we have to be careful about the use of the word relevant, right? Because I don't know about everyone else, but I scan all the financials to see if I find stuff that's relevant for custody.
Mm-hmm.
So we may just have to think about the wording, but I think we're certainly on to something that will allow a reasonable balance of interests to be able to get through and not make anybody feel like it's too burdensome or they're inundated with too much stuff.
And also maybe the limited appearance lawyer could request, something about requesting the documents too. I don't know. Clearly something we need to think about.
Yeah, no, that's really great feedback. I think to be more clear, Catherine, I think we'll go with reasonably relevant. Everybody knows what reasonably relevant.
Let's add another word in there to describe that.
Yes.
Pertinent. Put pertinent in there too.
Right. And prompt. Okay, that's really great feedback. Thank you for that. Okay, well, we've got some tweaks to address, but I guess unless there's anything else, Mary, do you want to move to the scope section? I don't want to rush us past this. If there's this is the great time for feedback and all that, but we're happy to move on if we're ready.
Okay. So the next section first starts by stating the attorney's activities need to be restricted to the scope that's been put forth in the notice of limited appearance. And then this goes on to talk about a couple of different scope issues. The first is that if the attorney files a pleading or motion that's outside the scope, then they will be deemed to have entered a general appearance. Then the next provision goes to the opportunity to file an amended notice of limited appearance. I think it speaks to what Judge Harrison Mitchell brought up, that sometimes they know that they want to expand that, and so it speaks to the ability to file an amended notice that would expand the scope a bit. And then the last piece basically says that the court could, if it's in question, if the scope is in question, that the court could set a hearing to determine the scope of the limited appearance. So all different pieces that have to do with scope of the representation in this section.
Can I make one suggestion there? In B, under B, I would suggest changing it to shall file an amended notice of limited appearance if they have extended the limited appearance to other activities, and not just may. I think it should be required that they file it.
Mhm.
So that everybody
I
is
agree
on
with that.
notice of that extended limited appearance.
Yeah, I think that's a good idea.
That's great. Thank you.
I was going to add in C under the, if the scope is disputed, I don't know if we want to limit that to only the court can set a hearing. I mean, what if I'm on the other side and I really don't understand what the scope of the appearance is, and I may, just to protect myself, want to set some sort of clarification hearing to figure out exactly who's representing what on what.
Yeah, that, Catherine, this was something I think I had put in some additional language at one point when I was working on my own edits of upon motion of the opposing party or any of the parties. And maybe there's there's a third party out here. Maybe it's the court just on its own motion, a sua sponte sort of thing. And that's when I took all that out and just said the court can set something, because it's not prohibiting or empowering anyone in particular to initiate that inquiry, but just that I would kind of presume, and this may be faulty, but I'd presume that this just it kind of puts everyone on notice that the court can set a hearing to determine the scope, but that really that can be initiated by anyone involved in litigation. But maybe we do need to flesh that out a bit more. See, Dr. Rice has his hand up. Dr. Rice?
Thank you, Brian. I wanted to ask, yes, can you hear me?
Yes.
Okay, I wanted to ask about what if because we have some of this where they're only filing the papers, they're like getting the process started, but they're not appearing for any matter. With that, I mean, because I'm looking at the overall, it says Unbundled Legal Services Subcommittee, which is what we are. Do we want to have something that addresses if they're just getting court dates for them, doing services that doesn't require an appearance?
There certainly were provisions in some of the other rules that just basically acknowledge that assistance in drafting or preparing a pleading, is allowable, but it generally wasn't within the same limited appearance. Like, it was basically separate from, because it doesn't constitute an appearance in the proceeding. There were some rules that just kind of acknowledge that.
Oh, I agree with Dr. Rice. I think we need to put something in here, I guess, that would allow lawyers to help prepare. They won't be signing the pleading, but could actually help prepare a complaint or help prepare an answer or prepare something without that would be okay. They're not actually making an appearance. Given it
like calendar motions, just people, pro se defendants or pro se folks get so confused about how to properly get something in front of a court for a mere motion. And so if I think it does need to be addressed that the attorney can do that without, and that's not really making an appearance in the sense the word using it.
Yeah, even something as simple as a motion to extend time to answer.
You can prepare that, but not sign it. Obviously,
Yeah.
none of these pleadings would be signed by the lawyer, but actually, I mean, that would be so helpful to a lot of people if a lawyer would just help them prepare an answer and counterclaim.
Yeah, or a motion to extend time to
That's
answer.
right. That's right, Daryl. Any of that stuff, yeah. In fact, that might be used even more than some of this.
I totally agree.
Is that something that we could, going back up in A, limited appearance, sort of define what an appearance is? And maybe, I don't know if we want to say what's not an appearance, but put some clarification there as to when this rule applies, because I mean, I look at it as you're not making an appearance if you're not signing any pleadings.
Yeah, but you want to make sure that it's okay. And there's some, I mean, you got to make sure that it's okay to do that. I mean, let lawyers know it is okay to do that without making an
Right.
appearance. Yeah.
So, and
Right.
to that end, we do have ethics opinions that allow lawyers, that specify that a lawyer can assist a pro se
Right.
litigant, essentially with ghostwriting and all that kind of stuff without making an appearance, unless, there's some law or court order that requires them to disclose that. And so I think that's where, we were kind of looking at, you're right, this is the scope part, right? We're talking about appearances because we're talking about Rule 16 and how folks don't want to get kind of tied to a case indefinitely, and this would allow them to get out. I think pleadings or drafting is, I guess I do look at that as outside the scope of this rule, because you're right, you can help somebody draft something, and that can be a part of the resource that we were going to put together, because I think this is something else that Mary and I were going back and forth on whether it's I guess we want to make a resource. We saw in other states, there's plenty of resources, handbooks and so forth about how you make these limited appearances and make them effective for the client's benefit. And there's some stuff that needs to be in a rule, like how you get in and how you get out in front of the court. But then there's also this other subset of services like you're talking about that aren't appearances. You're not getting into court stuff, although you're helping the client draft something, but you're not putting your name on anything. That's ethically permissible. And I think we can get into kind of the ethics aspect, but I don't think the rules of practice really touch that. So it might be clarifying here. I need to kind of look back at the language and see what can we do to clarify, maybe even just having something in here that says, this is focused on court appearances where you're putting your name on something as the attorney of record, but that other limited representation that don't involve a court appearance are still permissible, and provide some, I guess, some guidance in that regard, because we want folks to know about it. Anyway, these are all great points.
Brian, you probably would be surprised at the lawyers that don't know they can do that don't know that they can help ghostwrite a complaint or a motion or help somebody. And I guess I hear what you're saying. It really didn't need to be in here because that's not what this is addressing. But maybe if there's a way to put this in here and say that, just make some comment. I don't know that.
Yeah, I see exactly what you're saying. Because again, this is
Helps
supposed
to
to
educate. It helps educate.
Yeah, educate, empower folks. I see what you're saying. We'll take a look at that from that perspective.
Yep. Okay.
Can we
Catherine,
go back to that CC scope CC?
Yes.
You don't mind? I think I agree with Catherine, and I think that the wording should be changed to speak to any party that can set a hearing, as opposed to, because this does read as if the only person that can is the court. And I think we should consider here, just like with B, that it shall be set. Well, no, I don't know if you know what, now that I think about it, I don't know if I want it to be a requirement that every time it has. Well, I think it should just, I think it should just be that either party can, just like with everything else, that they set it on promotion or whatever, and it is properly noticed to be set for hearing.
How about a simple fix? If the scope of representation is disputed by any party, the court may set a hearing.
For the court.
Or that a hearing may be set.
Yes, I agree with that.
I mean, I think
the clerks get inundated with this by lawyers a lot of times, that is something that has to be done by the judge, as opposed to the parties can notice it themselves. And so just to make it clear, that way to alleviate the clerks getting bombarded with this different interpretations, I think we should just be very clear that it could be anybody setting it on for him.
On proper notice, like we normally do any other motion.
Absolutely.
It has
Yes,
to be by motion and on proper notice. That's
absolutely.
how we do it.
I made all those notes. Does anyone else have thoughts about the scope section?
Oh, looks like we can move on to sub D.
So then this, again, is sort of, I think, anticipating issues that may come up in these sorts of scenarios. So these are a couple additional requirements. The first of the requirements is that the attorney who is receiving, pleadings or notices, and they don't intend to participate in a court proceeding has to affirmatively inform the represented party, the opposing party, and the court that it's outside the scope of the limited appearance. And then the second requirement is a similar issue, kind of as noted above, wanting to be clear that on a given issue, the represented party and the attorney cannot both be arguing on a legal issue during the period of that limited appearance. So just a couple of things that I guess courts anticipate come up that are being added here as part of those rules.
How do you anticipate the first requirement being communicated to the court? I mean, you're not saying that the limited scope attorney has to file another pleading, or I mean, is it just email the TCA, email? I mean, that's one thing, but to require them to now have to file another motion and file it, that doesn't make sense, or notice or whatever, that doesn't make.
Yeah, I think
Yeah,
that's
the language.
Go ahead.
I was
Mary.
going to say the language we included is vague. I guess it says must notify, but I hear what you're saying, Marcy, on that one.
Do you
The other
think
thing I
that's
would-
even necessary?
Yeah, that's what that's kind of what I'm wondering, except that I guess the reason for doing it would be so everybody's not sitting around guessing if this is part of the limited scope or not. And if it's all it is an email to the opposing counsel and to the clerk or somebody that this is outside of the scope, and that but I don't know. I'd be curious to see what other folks think about that.
I think if you email it and then we're back up to CC, if somebody on the other side thinks it's a problem. So if Marcy communicates to me that she thinks it's outside her scope and I dispute it, then I'm filing that motion. So I think a simplified communication is fine.
So I had two comments. I feel like we're putting, and I know why, we're putting a lot of burden on this limited scope person. And that they're having to now, sort of monitor the court proceedings and make sure that they're giving notice. And I understand why, but I also don't want to deter people from, participating on the basis that they have all these other sort of hoops to jump through. The second thing I would note is, at least in Wake County, when we've had things like this, the judge has been the determiner of how long someone's going to stay and whether or not they will appear. And I have seen judges plenty of times make someone sit through an hour or two hearing, even if it's not in their scope. And I don't know why, but that's, again, not having this rule when it comes up and we have that limited scope, we almost always have our judge say, yes, you're excused, you don't need to be here, or no, I want you to wait. And so I don't know how judges would feel, Dorothy, about the attorney being able to make the call as to whether or not they're going to show, and you feeling like as a judge, nope, I want them here for whatever reason.
Yeah, I'm sitting here trying to think about how this could come up in the practical sense. And I was kind of thinking about this in a different way than what you all were speaking about it. So I need to think about it more to answer that. But what I was thinking about was if the language was changed to if the attorney is not required to participate in a court proceeding because it's outside the scope of their limited appearance, changing the language to that, because it seems to me like if the person, they've entered their notice of limited appearance, and I'm maybe just being naive in this sense, but it should be very clear as to when their court appearance is required based on that limited, the limited scope. And so I would think that it would need to be changed to, if their attendance is not required because of their limited appearance, that they must notify the represented party, the opposing party, and the court of their intention to participate. So I was kind of thinking of it in the opposite.
On the flip side.
Yes.
I see what you're
I'm
saying. I didn't know if I wasn't expecting that ending. But I see what you're saying.
I
That's
kind
that
of like
wow
it.
factor.
Right. I kind of like it, but I guess I would need more time to think through it. But it seems like it's a little less burdensome than for the limited appearance attorney.
Absolutely.
And with all due respect to Dorothy, I mean, we really aren't trying to give the court, we're sort of trying to take away some of the court's authority to make people stay in cases. I mean, we're trying to kind of, you know what I'm saying, Dorothy? I mean,
Yes, I do. And I would think that the times where Catherine, this is maybe another way and I'm being naive, but I know for me, if I'm having somebody to stay in, which I haven't done, by the way, had somebody just sitting around when they're not, there for the full case. But if I did, it would be because I thought that they would be helpful in some way, not because I just wanted them sitting around. You know what I mean? It's just that I know attorneys, right? I know certain attorneys, and I'm like, oh, if I just keep them in here, then they may be able to kind of move this along and help in some way. You know what I mean?
No, absolutely. I think our judges do it for a reason. And frankly, where I've seen it the most is when the party has been appointed an attorney as part of a contempt issue.
Yes.
And I mean, obviously that's a little different, but that's where I've seen judges say, you're going to stay for the first part of this hearing. But I've never felt like a judge has done it just randomly. I'm sure they have a reason, and you're right. It may just be to sort of help the process along.
All right, well, I think maybe I'm going to mark this one as one that we probably want to give some additional thought to. And I think one of the additional options here is to, as Mark put in the chat, Mark had to leave. He had a hard stop at 3:00 to delete section D. That maybe D just adds more confusion than clarity. And I think that's something to consider here, whether it's truly necessary. And I know we are at 3:00. It's 3:02. We had one more section to go. Catherine, I'll leave it to you. Do you want us to just reconvene and talk about that, or do you want to touch on that briefly?
Let's at least touch on it briefly. I mean, it may go into a big Pandora's box, but let's at least touch on it to see how if people are liking sort of because this is the only option where we've had an alternative. And maybe we can kind of give you an idea if there's one alternative that most people are in favor of.
Okay. Mary, do you want to go over that one?
Sure. Okay, so in the withdrawal section, this is sort of what has to happen in order for the individual to get out of the case. You'll note that the B section is the same on both of these options. So, and that is in the event that there is not consent of the represented party. So I'll start with the first one. It's basically going through requiring the represented, if the represented party does consent, requiring the notice to be filed. The court would enter the order to withdraw if there was not good cause that exists. And as we've noted, the party signs this. That's sort of showing their consent to the withdrawal, I would think. The other option, which is below, the A that's below, is not that a notice is filed of withdrawal, but an order filed that's basically presuming that the attorney is withdrawn, that the appearance has concluded. Again, it's signed by the represented party. It goes on to describe that the information that is required to include the address and stating what should happen about future filings, but it's sort of a shade of difference between the two. When there is consent, where you're filing and then, you know, the court is ordered to make the withdrawal, or you're basically filing an order of withdrawal. And the court, if there's, you know, the court looks at it and says, well, that's not right, something's wrong with that, they can, within their discretion, you know, tell them to appear to come back. But it's just, I guess, how affirmative do we want to be in the event of consent? How affirmative do we want to be that the attorney can either file to get out or pretty much order, you know, submit an order that they're getting out. And then the second section goes on to talk about what happens if the represented party does not consent, giving an opportunity for anyone to object. And then if there's no objection, the court orders the attorney that the limited appearance is concluded. If there is an objection, then there's a hearing. So those are sort of the two options that we've come up with.
Catherine, I like the second one.
Yeah, I was going to say, I like the second A.
Yeah. Do we have any more
Anybody?
votes?
I was going to say, anybody want to argue for the first A?
I like the second. I like the second A too, but I'd love to hear what Judge Dorothy has to say.
I like both of them actually. And like, I initially was going with the first option because it seems to be more clear to the pro se person. Because when they get an order from a judge, that just seems to, for some people, just mean so much more to them. But I like the second option, especially because it alleviates more of the steps. And it still gets to the same result, especially with consent, especially, you know what I mean? Because I can tell you when I get those withdrawals now, I'm definitely looking for a signature consent by the party. And if I don't see it, that's when I have the biggest problem. Otherwise, I mean, it's kind of standard to just grant them if there's the party consents. So we're ultimately getting to the same result. It's just more steps. So I can deal with the second option for sure.
Yeah, and that was something I would say when I drafted the second option. It was kind of a thought of the potential for, if one of these motions to withdraw gets held up, if there's a delay in actually filing that order, then opposing counsel, what are they doing? They've got motions to file, but the person has noticed everybody that the limited scope is over, but that limited person is still technically in the case. Where do I send everything? And I thought that allowed a bit more certainty to everybody, but still provided the avenue for the court or otherwise to basically pull somebody back in there. Of course, it's all premised upon the consent of the parties, that it's limited appearance lawyer and client are saying, this is done, and lawyer's out of it. I'm back to being unrepresented. So kind of try to create that pathway.
Yeah, and you're trying to make,
great for all those reasons.
yeah, you're trying to protect the public. I think the alternative does that because they're signing it. But you're also trying to make it easier for people to get in and get out, to encourage people to do it.
Right.
So I think we stick with the alternative, because I'm sure we'll have another draft, and then we can just look at just that language and pick it apart.
I've got a comment on that. I'm actually listening, even though I'm not on camera. So good afternoon, everybody.
Well, we see you now. You're on camera now.
Yeah, I turned my camera on.
Hey.
Hey, everybody. I'm sorry I've been off camera. It seems to me that alternative A has a contradiction in it. The third sentence says, upon the filing of it, the lawyer shall be out. It shall be effective. But then the judge at some point after the filing of it can then hold a hearing. So if the judge can't hold a hearing for a month, is the lawyer out of it for that month? Is the client unprotected for that month? It seems to me that the way the third sentence is written, once filed, it is effective. Yet the fourth sentence says the court may then, in its discretion, order a hearing on it. So that seems to me to be contradictory. And to leave the client without a lawyer for however how long the judge can have the hearing and the judge may disagree and then make the lawyer stay in. So I think there's some tension between sentences 3 and 4 there.
We have to, well, you have 10 days to object, so maybe.
No, that only applies to the parties. That doesn't apply to the judge. You can't say the judge. You got to object within 10 days to what the lawyer filed.
And I think, Todd, you're right. And Marcy, what you just pointed out is maybe a solution, that there needs to be a time frame
Yeah.
that after filing, maybe it's not effective upon filing, it's effective 10 days after filing, during which that time, like, it kind of puts it on the judge to potentially order a hearing. And I think that's this is what we're trying to strike here, is this thing where it allows a presumption of the lawyer to get in and get out as cleanly as possible. And I would like to think that most of these limited appearances would be just that. Everybody agrees and everybody goes on with their merry way. But if the court needs to say, wait a second, the way this limited appearance just went down, I think it would be very harmful to
That's
our
right.
process
I think
for you to
that's
get
right.
out.
Yeah, I think that's right. That's the tension between 3 and 4. We need to pay more attention to that. And I'm quite frankly not persuaded that these judges are as great as Dorothy is. Obviously, other judges will have their own point of view, and they may want to study things a bit more before they let people out. And taking away their discretion may not be well received.
And that's an excellent point, Todd. I think we also probably need to clarify what is the limited attorney's responsibility between whatever time that notice is given about the hearing and the hearing occurs. Are they in it? Is there a presumption that they're in it or not? I just think we need to spell that out so that they're aware.
Yeah, or whether it's like most, we're changing all this, but some judge may say, I want to be the final arbiter of when it's effective and not when you file it, but when I look at it and decide that I'm entering an order approving it, and you're out at that point. So I just want us to study the tension between 3 and 4, and keep in mind, judges are of different minds, and sometimes they say, I'm the final judge and not the lawyers. And so just think about that. Sorry to prolong it, Catherine. I opened my mouth and I should have stayed off camera.
No, that was an excellent point. The good
Thank
news
you
is
for
at
that.
least we know.
No, I'm sorry, Catherine.
Well, I mean,
No, go ahead, Dorothy. Go ahead, Dorothy.
I was going to say thank you, Todd, for that compliment. I'm trying to do my best in that regard. I was going to say that if we are going to look at that, because you do raise a good point that those two sentences are in conflict with each other. And if we're going to look back at some time period for objections to be filed and all that, we might as well just keep with the first provision and just leave it with the judge, sitting with the judge for whatever amount of, for them to just sign the order. Because either way, if they're going to have some ability to have a hearing and have to make a decision on it anyway, it may as well just stay in there forever you in the first place. I mean, all the way around.
That was sort of my thinking. Yeah.
I'm still not there. We can talk about it some more at the next meeting, but I
could just say, Marcy, for the judges, at least for me, if I'm going to have to look at all of them anyway, I may as well just go ahead and sign orders for all of them, as opposed to, it doesn't really make sense to have some that I'm looking at and some that I'm not.
Well, and Dorothy, you're very, very, I'm sure you're on top of it and you look at your orders and you get them signed, but then there's some judges may sit on this for 30 days, 60. I mean, there's got to be, again, we are trying to get lawyers to come in and do free work. Okay. You're going to make it harder for them to do it. This is not even worth our time that we've had sitting here today.
Well, I think in that, I agree with you, Marcy, and you're right. I am a type A in that regard, and I don't want to sit around. I can't stand the fact right now that I don't have some that I'm working on while I'm on vacation.
Right. You're the exception.
But
let's do it
maybe put a time period in there for the judge, like put a provision that says that the judge has to review it within a certain amount of time, kind of like what we have to do on those emergencies and things.
Good luck with that in Mecklenburg.
Why don't we do this? Why don't we do this since we're over time? I was hoping that we could narrow this down, but maybe we should just leave both of them in there for right now. And then when we come back, everyone at least is somewhat aware of what the issues have been and what the flags are. And we can come back and analyze the two options again versus sort of digging in on one or the other.
Agreed.
Good.
Sounds good.
This is good stuff, y'all. Like really.
I love the debate.
Yeah.
Mhm.
Well, and
This
I just
is
want to
deeper.
say to Mary, and Brian, you all did a great job because we were so great in telling you just to go create some magic, and we gave you no guidance. And this is great. I mean, obviously, don't take any of the fact that we had a lot of debate as negative feedback. I think that's actually the positive feedback.
That's right.
That you guys did such a great job. So,
Absolutely.
and so I guess the next action item is goals for next quarter.
So I think we've got a lot of great feedback here. Mary and I will put our heads together and come up with a new draft. Realistically, I don't think we'll have another meeting before the July meeting, but I'd like to set a meeting early in the next quarter so that we can take a look at the next draft and potentially have a second meeting during that next quarter. I personally think it feels like we're really heading in the right direction. And I think it might be attainable to actually have something in October that we could have for the council's consideration. So that'd be my proposal, Madam Chair.
I think that's perfect.
Right.
So,
And I do apologize. I saw Matt, your comment. Yes, I need to give that kid a cookie. I had a kid walk through the background against my order, but
There's a long running joke about that, y'all, about me directing Brian to give his child a cookie based on a phone conversation, like 2 or 3 years ago. And
yeah.
every time you see Brian's children, offer them a cookie.
And then walk away. Thanks, Matt.
Make sure that appears in the minutes, please.
Right. Yeah. It's live streamed. Great.
Well, thank you all. You guys have done a great job. Brian and Mary, you guys have, as always, done a great job. And so I guess we'll just get a email about a survey for another meeting, probably in August.
Yes, we'll do that.
All right. Anything else?
Everybody have a great 4th.
Yeah. Have a good holiday. Look forward to seeing some of you in Asheville in not too long, couple weeks.
Yes.
Yeah.
Great.
All right.
Thanks, everyone.
Have a good one,
Get your
everybody.
dancing shoes on.
Thank-
Get your dancing shoes.